Hello and good afternoon, ladies and gentlemen. It's yet another exciting day to be alive, and more exciting that it's Friday and is a very special Friday indeed. I hope you have been well and I hope you are hydrating because the heat wave is sweeping across. But while you hydrate, ladies and gentlemen, we have a very interesting topical discussion this afternoon centering on mastering dispute resolution in East Africa's key growth sectors. And we'll be looking at practical tips for legal practitioners in Africa and beyond. We are so delighted that we have a very rich panel that is here that includes eminent excellencies of the East Africa Law Society, the Federal Bar of Ethiopia. We have the chairperson of SIAB Kenya branch. We have Honorable Justice on this platform. So it's indeed an incredible session. So if you are joining in, please, you are welcome. Feel at home. East Africa Law Society is your home. And we are streaming this session live on our YouTube platform at East Africa Law Society. So please share the link with a colleague, share the link with a friend, and enjoy the session. I will now hand it over to Ms. Evelyn Kimani, Business and Development Manager, SIAP Kenya, to take us through proceedings of the day. Evelyn, good afternoon.
Gabriel, you started us on a very light, lively note, and welcome to the rest of our panelists, the rest of our participants. Mine is just to highlight what the Institute is about, as I invite our panelists, just 5 minutes of your time. So the Chartered Institute of Arbitrators is the premier organization that deals with resolution of disputes, and especially ADR mechanisms. And we have similar such platforms to sensitize and to create awareness on how the various ADR mechanisms are used and how the lawyers in this case can be able to strategically position themselves either as counsel or either as dispute resolvers themselves. More will come later on during the presentation. So I will not take much of your time. And in this moment, I would like to introduce the president of the East African Law Society to make his opening remarks. Welcome, Mr. President.
Thank you very much, Madam Evelyn. It is an honor to address you this beautiful Friday afternoon. And I'm not here alone. I'm accompanied by the president of the Federal Bar of Ethiopia, Mr. Tedros Getachew. Allow me to show his face. welcome, Mr. Getachew. To the members, ELS, composed now of 8 countries, and Ethiopia is one of the latest entrants of East Africa Law Society. And being that we're having a meeting today as the ELS Governing Council, and the president of the Ethiopian Bar was present, I found it fit to have him also address the membership who are attending this afternoon session. And I'm sure from the panelists, you've also seen our Lady Justice, Madam Madot, from Ethiopia, who is also present to address us on matters ADR. But before I make my remarks, allow me to invite the president of the Federal Bar of Ethiopia, Mr. Getachew, to say a word. Karibu.
Thank you, Mr. President. Hello, everyone. Good afternoon from the very warm Zanzibar, and we're having here a governing council meeting, and was a coincidence that this webinar is going on at the same time while we're holding our governance meeting. So it gives me a pleasure to address you from here and to address you in this important event to discuss your alternative dispute resolution, ADR. And this webinar is timely and relevant for Ethiopia and also for the African lawyers in general, and more specifically for the Eastern African region. As we know, there is a huge gap in the area of ADR including international arbitration. And these gaps need to be filled by us, the bar leaders, the regional leaders, and the lawyers, law firms, and all of us, including the government, relevant authorities, so as to address all these gaps. ADR not only provides a neutral forum in resolving dispute resolution, especially cross-border dispute resolutions, but also it overcomes the challenges regarding the unfamiliar and complex domestic procedures, which are usually a discouraging factor for investors, even for us lawyers. So it is an untapped potential that we all need to work on with a more engagement is expected from all sides who are stakeholders. So myself, my bar, the Ethiopian Federal Bar, and on behalf of the ALS, here I'm with my president, we'll be happy to explore the options to engage together towards a robust ADR system in the Eastern African region and beyond. I also want to thank our ALS Secretariat for successfully making this webinar, for their hard work. And I'm very happy to see Honorable Justice Maadot from Ethiopia, and we're looking forward to more engagement from all Ethiopian lawyers. ALS is yours now, so all of you probably hearing me behind the scene. We need more engagement, not only as a participant, as a panelist. ALS is yours, so we're looking forward more engagement from all sides in the Ethiopian legal landscape. So not only the lawyers, the judges, prosecutors, in-house counsels, all, but the legal community in Ethiopia is expected to take its own huge share in the Eastern African legal sphere. So I wish you all the best. I wish you a successful webinar. So I'll be getting back to President.
Thank you.
Thank you so much.
Thank you so much, Mr. President. Allow me to now make my remarks. Honorable Lady Justice Medot, the Chairperson, Chartered Institute of Arbitrators Kenya, Ms. Jacqueline Waihenya, the President of the Ethiopian Federal Bar, esteemed panelists, distinguished colleagues, and valued colleagues. Good afternoon. It is with boundless pride and purpose that I welcome you to this landmark symposium. On behalf of the East Africa Law Society and in cherished partnership with the Chartered Institute of Arbitrators, I extend a resounding salute to each and every one of the legal luminaries, dispute resolution trailblazers, and guardians of justice gathered here to shape the future of conflict resolution in our vibrant region. East Africa stands at the crest of an economic renaissance. Banking is pulsing with innovation. Real estate is rising to new heights. Energy is powering our ambitions. Construction is booming our dreams, and technology rewrites our possibilities. Yet, with this meteoric growth comes the shadow of disputes, complex, urgent, and inevitable. In this crucible, arbitration, mediation, and negotiation emerge not as mere alternatives, but as indispensable instruments of stability, ensuring business thrives, investors trust, and progress endures. Today, we embark on a bold exploration. We will unravel our ADR mechanisms can be utilized to fortify our key sectors. We will dissect advantages of ADR over courtroom battles. We will also confront sector-specific challenges and illuminate pathways to enforce our rights across borders. From the intricacies of drafting ironclad clauses to the artistry of mediation, we'll distill best practices and chart opportunities for legal minds to rise as specialists in this dynamic field. At the East Africa Law Society, we are more than a voice for the law. We are its vanguard, and we are focused on forging bridges between ambition and resolution. Together with our partners here at Kenya, an unrivaled beacon of arbitration excellence in Kenya, and the region. We want to use this platform to empower practitioners, elevate standards, and weave a tapestry of collaboration across our region's dispute resolution institutions. Our panel titans includes renowned experts, including Mr. Calvin Nyachoti, Mr. Ken Melly, a gentleman I've had a chance to work with in several petitions before the Supreme Court. And we are also honored to have Honorable Justice Medot Tesfaye from the High Court, the Federal High Court of Ethiopia. We also have Ms. Ida Juma, a good friend, and Ms. Francois Ingabire. They all bring unmatched wisdom to this stage. Their insights will not just inform, but inspire, equipping us to master the evolving landscape of ADR. So with fervor and foresight, I declare this webinar open. I charge you, engage with passion, question with courage, and innovate with resolve. Let us not only navigate this new frontier, but define it for East Africa, for our professions, and for a world that looks to us as architects of justice. Thank you and enjoy. Back to you, Madam Evelyn.
Thank you so much, Mr. President, for opening that session for us. We are experiencing some bit of technical challenges with our chair, so as we're trying to correct that, I would like to request our moderator of the day, who's Karen, to introduce her panel as we await for the address from the CIAB Chair, Jacqueline Wahenya.
Sorry,
Thank you,
Evelyn, I think I'm online now.
Ah, perfect. Welcome, Chair. Thank you.
Okay, yes, thank you, and my sincere apologies for jumping in a bit into the webinar. And I'd like to take this opportunity to welcome you all to Mastering Dispute Resolution in East Africa's key growth sectors, and we'll be offering a practical guide for legal practitioners. Allow me to recognize the presence of East Africa Law Society President Ramadan Abubakar and the President of the Ethiopia Bar, and all the panelists that will be addressing you this afternoon. We're expecting to have a very exciting engagement, hearing from leaders in the different parts of our region, and they will be speaking to you on alternative dispute resolution. On my part, I prefer to think of it as appropriate dispute resolution. There are various mechanisms: arbitration, mediation, construction adjudication, conciliation, and CIAB Kenya is leading in training in this different mechanism. And so we get very excited when we see the emerging excitement about ADR. And truly, arbitration first is a bridge between different jurisdictions, and all the other mechanisms tend to fall into place. And each one of you is going to learn something new. I always learn something new when I attend a webinar like this, and I'm looking forward to hearing my colleagues at in ADR, the practitioners who will be speaking to us this afternoon. Also, allow me to recognize Honorable Lady Justice Medot Tesfaye, and also my former chairman, Calvin Nyachoti, chartered arbitrator, and our good friend from Kigali, Francois Ingabire, from Kigali International Arbitration Center, and also Ida Juma, who will be speaking to you, and we are going to be very ably led by Karen Rono. Allow me to also mention that I'm currently in Zambia. We had the Lusaka Arbitration Week. Africa is really picking up on arbitration and ADR, and it is becoming, and if it has not already become, the choice for dispute resolution settlement across the continent. And we're all looking very keenly to see what AfTA is going to do for us, the Africa Free Commercial Trade Area convention that has already come into force, and also what it means for dispute resolution as we move ahead. So today is a day for exploration of what we can anticipate to learn and to see. even as we move into this new, very exciting space. So CIAB will continue to lead in all matters ADR in training. We also do appoint neutral. So when you become qualified, this will be a home for you. And yes, I can confirm that we do appoint members from different countries in East Africa, and we look forward to expanding our net and also growing the footprint of ADR. So we are in for an exciting afternoon. Probably to just let you know that after we do the sensitization today, there will be an opportunity to train, and we have the introduction to domestic arbitration coming up on the 2nd and the 3rd of April. It's a very, very affordable cost of $405 US. And I'm quite sure that those who would take the challenge, and I am throwing the challenge at you, it will change your life. For me, I would say arbitration and ADR changed my life, the way I view dispute and resolution. And I'm quite sure that when you add it to your own repertoire, you find a way to ease how you support your own clients in the journey. And it is also a very, very viable professional path for everybody who is keen on spreading their wings, expanding their knowledge, and also having a significant impact on what is happening in your respective jurisdictions, because the world is changing, the globe is shrinking, and everything that we do is all connected. And I want to invite you to connect through ADR. We have a vibrant community, and we are looking forward to welcoming you to the practice of arbitration and ADR. So I do tend to get quite excited when I speak about arbitration and ADR. Allow me to stop there for now, but we will be happy to take any questions, any comments that you may have, any clarifications. But without further ado, let me welcome you into the world of arbitration and ADR, and I guarantee you that your life will never be the same again. Thank you, Evelyn. Maybe you can continue to hand over to Karen Rono, which I know I rudely interrupted you on. Karibuni sana.
Thank you, Chair, for that. Allow me the privilege to also welcome Karen. Karen is an advocate of the High Court of Kenya. She's a member of the Chartered Institute of Arbitrators and the principal partner at Chelangat Law, a boutique law firm here in Nairobi. She'll be a moderator for the day, and I know we are in safe hands. Thank you. Welcome, Karen.
Thank you very much, Evelyn, and thank you so much for those kind words. Thank you, Madam Chair. Thank you, Mr. President. And also thank you for saving me more time to allocate to my panelists, because that was one of my worries. So without further ado, members of East Africa Law Society, members of the bench, members of the bar, my fellow colleague, welcome to today's conversation on mastering dispute resolution in East Africa's growth sectors, which is essentially supposed to be a practical guide on how you can plug in to this particular industry. So the key question that we intend to answer today is, your industry is advancing, but is your dispute resolution strategy strong enough to keep up with all these advancements? I'm honored to moderate this particular conversation, and I have a distinguished panel that covers several jurisdictions, and their experience spans different industry and practice areas. So without adding so much to it, allow me to just mention a few things about them, and then we'll shoot straight in. So my first panelist is Mr. Nyachoti. Of course, I had to go to Chairman Emeritus simply because I am a member on this end. So Chairman Emeritus is an accredited Chartered District Arbitrators tutor and a partner at Nyachoti and Partners Advocate. He has vast experience, and he has been instrumental in advancing ADR mechanisms across East Africa, and might I say across Africa. If you come to the Institute, you possibly might be tutored by him, but he will tell us whether he's still in the calendar for this particular set of trainings that are coming up. Allow me to just introduce all my panelists, and then I give them an opportunity for each one of them to speak. My next panelist is Mr. Ken Melly, my senior, as I refer fondly to him. He is a partner and head of dispute resolution at Gumbo and Associate Advocate LLP, which is now referred to as G&A Advocates LLP, which is a boutique law firm specializing in commercial litigation, ADR, vis-a-vis, and he, like Mr. President said, he has vast experience within this field. And one of the things he's constantly challenged me specifically is to go into the non-conventional, unconventional areas that we don't necessarily go to, especially the ESGs, the climate change and the like. So he'll tell us more about that as we continue. And this is me telling my panelists to stretch their wisdom to several areas. My next panelist, who yesterday I had to ensure that at the very least I try and pronounce her name properly, is Honorable Lady Justice Maidot Tesfaye. She's a judge of the Federal High Court of Ethiopia. She has a deep judicial experience. She will offer us critical insights into the evolving role of arbitration in ADR in East Africa, specifically Ethiopia, and I'm genuinely looking forward to it. One thing I must remark is she is such a calm, composed spirit. And one of the things I am looking forward to is in future to work with her in several other industries. I'm not sure which one, but I am throwing the net out there, hoping that the fish might be caught. My next panelist is Miss Ida Juma. I have just noticed there is a call for people to join committees within the East Africa Law Society. So she is the managing partner at DLA Piper, Burundi. And the reason why I added this bit about the committees is she's the chairperson of the East Africa Law Society Dispute Resolution Committee. And I know at this particular moment, she might need members. I'm not sure about the deadline, but she let us know. As a leading advocate for dispute resolution in the region, she plays a key role in shaping ADR policies and best practices. And then we have none other than Ms. Francois Ingabire. She's a case manager and capacity building specialist at the Kigali International Arbitration Center. Her expertise in case management and institutional arbitration ensures that businesses and legal practitioners can effectively navigate ADR processes. I am looking forward to her giving us an institutional perspective in this conversation. So for those of you joining us for the very first time and hearing the word arbitration within the legal space, this is a safe space. Please grab a notebook with the heat wave, grab a glass of water, and please be ready to learn. So I'll have my first panelist, Mr. Chairman Emeritus, going ahead to give his opening remarks and his experience within our jurisdiction, followed by Mr. Ken Melly, but I will help us navigate the conversation. Mr. Chairman Emeritus, please go right ahead. Thank you.
Thank you very much, Madam Moderator. A good afternoon to all of you. Allow me to ride on the protocols already set by my colleagues earlier on in recognizing everyone present in this call. Thank you very much, Madam Moderator, for the introduction. I'm honored to be with you this afternoon. By way of introduction, I am an ADR practitioner, particularly in the area of arbitration, in the area of mediation, and in the area of adjudication. I'm a legal and governance practitioner as well, and I've had the privilege to handle a number of arbitrations, a number of mediations, and a number of adjudications, both at individual level, but also within a panel. I am also Kenya's representative to the International Center for Settlement of Investment Disputes, ICSID, a position where we continue to lobby and to build the profile of arbitrators, but also to handle disputes as and when they come. I am one of the tutors for the Institute. And yes, Madam Moderator, anyone who enrolls in any of the upcoming courses is likely to have a session with me on either the introduction or module 1, 2, upwards, and I'm very, very happy to be part of that. My chair, Jacqueline Waihenya, did mention that arbitration changed her. I thought it was just me, but indeed, the very first foray I made into training for the introductory to arbitration course was a turning point for me, and I have continued to grow in that area. I am a past chair for the Institute and one of the leaders of the Institute, a position and a responsibility that I've enjoyed over the years. I'm looking forward to the conversation we are having this afternoon, basically deepening our knowledge, our understanding on ADR lines, and how is it we can bring everyone on board into this train. Thank you. Back to you, Madam Moderator.
Thank you very much, Mr. Chairman Emeritus. Allow me to just go straight to Mr. Melly. I am also trying to buy us time for an additional round. Mr. Melly, my senior, please go right ahead.
Thank you, Karen. And because of the limitation of time, allow me to also ride on the protocol as has been established. I have been requested in this session to share thoughts from the perspective of a practitioner. And I wish to just mention that as practitioners, the context in which we practice is very rapidly evolving. As an ADR practitioner, I think very many of the clients that all of us represent as practitioners have shifted in their businesses into new and emerging areas of business. There are developments within the landscape and regulatory environments that we all operate, and invariably, disputes will always follow the business trends. Disputes will always follow the steps that are being taken at regulatory level across each of the countries in the region. The region is increasingly connected. Again, with it comes a changing frame of the needs that our clients require. Now, with the rapidly evolving space that we operate from, and with contracts and businesses increasingly providing for ADR in one form or another as the avenues for resolution of disputes, then it becomes necessary for practitioners to be equipped with the latest information and skills to be able to serve better the clientele that the practitioners represent. It becomes necessary at a time when our countries are also signing treaties of different kinds, opening investments and business opportunities of different kinds, to be able to be ready to tap into the opportunities that come with those constantly evolving needs in the business space. And for us to be responsive in that space, I think I will comment on just some of the sectors that have been mentioned. The time allocated is certainly not enough to cover all of the sectors that are growing in this. Allow me to comment on some of the areas that are cross-cutting across the industry, and financial services is one of them. Very many of the contracts and projects that are being undertaken in our various countries are anchored on contracts which in one form or another require financing of some sort. And we have seen increasingly that those contracts provide for dispute resolution clauses, mostly for commercial arbitration, preceded by multi-tiered levels of dispute resolution mechanisms, starting in amicable discussions, going into mediation in some of them culminating in arbitration. So it becomes necessary for practitioners to be familiar with the entire continuum of processes that are required to serve these clients. Energy is another sector. Africa is a natural resources rich continent. And a lot of disputes and a lot of projects in the region are in one way or another connected with natural resources, with energy, with mining. And most of those, again, when disputes arise, open up opportunities into either domestic arbitration, and in most cases, in international arbitration through the various treaties, bilateral investment treaties that our various countries have signed. Technology is the other sector. Technology is rapidly evolving. It is said that, in fact, technology is growing and changing faster than regulation. As the regulators are handling the regulatory aspects of technology, there also is increasingly types of disputes in areas of technology, software disputes, domain name disputes, and the rest. Lastly, on those that I want to just quickly highlight, is with the international climate action agenda and the climate change issues and ESG, environment, social, and governance coming to the forefront of business and contracts across the region, we increasingly are seeing contracts and projects that have various ESG obligations. A number of those ESG obligations contain enforceable and actionable requirements for those contracts, especially those that are tied to financing of projects. So again, that, in my view, is another area that is rapidly evolving, and it then requires practitioners across the region to familiarize themselves. There are uniting factors. Most of the countries in the region, I think all of those represented by the East Africa Law Society, for instance, have interaction legal framework that either give them access to the New York Convention on recognition of arbitration agreements and awards. Those that also have subscribed to ICSID, the vast majority of the African continent are under the World Bank framework, members of the International Center for Settlement of Investment Disputes. And many of the countries also have the domestic laws modeled along the UNICITRAL model arbitration law. The result of this is that in a forum such as what we have today, there are very many connecting issues that transcend the practices in the various legal jurisdictions that we operate from. And that is why capacity building through the institutions available would be one of the things that we want to consider. For time constraints, I will pause there. Allow me to hand back to the moderator. I'm happy to provide further thoughts on any of the components that I've mentioned. Thank you. Moderator, are you able to hear me?
Perhaps we can go to Justice Tesfaye as the moderator comes back in.
Apologies.
Okay.
Mark. Honorable Lady Justice, you can go right ahead. Apologies for that.
Thank you very much. Thank you, Madam Moderator. Thank you, everyone participating in this very vital and interesting discussions on the key sectors of the key growth sectors in East Africa and how we can use ADR to promote such growth. In order not to repeat what my predecessor has earlier said in the introduction part, I would like to focus on the role of courts in ADR. As you know, the role of courts is very indispensable, starting from the commencement up to the enforcement of all ADR systems, including mediation and arbitration. And as mentioned, the East Africa is a robust economy where FDI investments are flowing, and key areas of investments in manufacturing, agro-processing, infrastructures, or mining or tourism would demand a robust dispute resolution mechanisms, and such mechanisms can only be fruitful by the positive and involvement of courts. And as in the context of Ethiopia, Ethiopia has currently amended the investment proclamation, allowing more foreign investors to be involved in the investment sphere, which meant more disputes, cross-boundary disputes are going to be coming our way. So we should be able to equip ourselves in understanding what is the landscape, the legislative landscape, the practical landscape of not only the country, but the region and also the world. And as part of the investment dispute resolution mechanisms, Ethiopia has also ratified the New York Convention on the recognition and enforcement of arbitral awards, followed by the promulgation of the National Arbitration and Conciliation Procedure Proclamation. And also court annex mediation programs have also been launched within the country, setting the ground for further developments. And as with the industries, I would like to comment on some of the key industries in dispute resolutions, like the construction industry, for example, where we are seeing a much more tendency to ADRs within the agreements made between parties within the domestic sphere, which meant that the old way of resolving disputes through courts as or litigation methods is evolving very much. And in this regard, I would also like to mention that it is very important to adopt not only the well-known arbitration and mediation schemes, but also other ADR mechanisms like experts' determinations, educations, etc., that are very relevant to the technical nature of such disputes. The other thing I could mention is with regards to technology and intellectual property. And with this, the same way, there is mainly these kinds of disputes are settled by quasi-judicial systems currently in our country, but there is a great potential that we will be moving towards ADR mechanisms so as to solve disputes in an amicable way and in an expedient and efficient manner. So with this, I would also like to mention that the court system have been continuously been tuning themselves with the progress with regards to ADR, and still the judges within the East African community should come together and hold each other together in sharing experiences and knowledge regarding ADR among the judges, the practitioners, and all over the community. And it's also very important that we come together in recognizing and enforcing the rule of law as part of the judiciary, in a sense that the independence and impartiality of the judiciary is very vital in any matter, whether it would be commercial-based disputes or any other disputes. So I would like to mention that it is very important to always consider the rule of law and the impact of the courts in upholding the the laws and working in an independent and impartial manner, and sharing such challenges among other colleagues in order to get out positive outcomes. So if I mention these very important points, I will address other points with coming up questions and questions. Thank you very much.
Thank you, Lady Justice Maidot, for that. And thank you for giving us a bench perspective on the same. And we definitely have a lot of follow-up questions in respect to the same. Allow me to invite Ms. Juma to run her opening session. But as she does the same, please let us know if you still need members of your committee, because it is still in line with this particular conversation that we are having. Thank you. Ms. Juma, please go right ahead. Ms. Juma. Okay. If she's having trouble, okay, we can go to Francois. Francois brings us an institutional perspective. So one of the things that we have realized in the course of our conversation is our panel, not our panelists, but our audience here have varied experience. So one of the things I'd like you to first explain to us is, what exactly do you do? What is the role of an institution when it comes to ADR? And when you say you're a case manager, what essentially does that entail? So build up on essentially that, so that at the very least, we are operating for a level playing field. Thank you. Francois, please go right ahead.
Thank you very much, Karen, and good afternoon, everyone. It's my big pleasure to be here with both emerging and experienced legal professionals to discuss this interesting topic of today. So before I proceed, I'm the case manager at the KIAC, and when I say I'm the case manager, is that I deal with case management of the cases, being arbitration cases, mediation cases, adjudication cases. So our role is to manage the cases from the start of the case to the end of the case. So from the start of the case to the end of the case involves so many things, including how the case is filed. Does it go with the rules of the KIAC? Does it have all the necessary requirements to be filed under KIAC, and also to direct either lawyers, parties on how to go with arbitration, because as you may know, arbitration now is ADR and arbitration are trending now, and they are growing day to day. And it is not always that parties or even counsel that know how to go with arbitration. Sometimes they don't know the procedures, so it's our role to explain to them what to do and the way forward, and then to review all the procedural work, and to review the awards where necessary. So to sum up, that is what we do at the KIAC. Going straight forward, we've had now so many sectors that are growing, and one or three of them I would mention is construction, technology, and energy, and also mining. So those are the sectors that we've been involved into at the KIAC. And but I don't want to repeat what others have said, and I just will go straight to the role of the institution, or the role of the KIAC or other institutions vis-a-vis how to deal with those sectors. So number one, we have, in East Africa, we have the Kigali International Arbitration Center, we have the Nairobi Center, we have the Tanzania International Arbitration Center. We have also, in Uganda, we have a center, ICAMEC, if I'm not mistaken, and Burundi, we also have one. So all those centers that I just mentioned are, they have the same mission, I would say. Like they have the rules that are used in terms of handling dispute, and the rules were designed, especially for Kia, they were designed to help the users. They were designed according to the model of the UNICITRO, which is, an international arbitration law, which helps. It has what it takes for a center to be on an international level when it comes to resolving disputes. And we've been also doing capacity building in terms of lawyers, other professionals, not only lawyers, and also the judiciary. Honorable Justice just mentioned something about, the enforcement of the awards and also the role of the court. And I would say that the court plays a huge role when it comes to enforcing arbitral awards and other maybe mediation settlements. And without a trained judiciary, it will be hard for those enforcement to go as planned. So we've been involved in training the lawyers, and maybe I would give a hint from out of almost 150 awards that we've got here at Kia, only 2 were set aside. So you can imagine if we did not invest in training the judiciary, I don't think it will have been gone that way. And also another thing is we have a pool of arbitrators, and I think that we share that with the Nairobi Center and other centers where we have a pool of arbitrators with the expertise, because as we mentioned that, they are growing sectors, and one of the things or one of the good things about IDR is that it's flexibility, it's efficient, yes, it's cost effective, but you have to appoint someone who has expertise in those sectors that you want to deal with. So we have a pool of domestic and international well-known arbitrators, and we think we are in a good position, I would say, to deal with the growing sectors. And we also now engaging in technology, because you see, everyone has mentioned about technology in terms of sector growing, but also technology in terms of ADR alternative dispute resolution mechanism, which means that we are now conduct virtual hearings. We actually about to launch the case management software, which will help users to cut the cost in terms of when they want to file a claim. So we believe that it's going to help the users, the clients, and the lawyers in terms of if I want to file a case, I don't have to go there. I don't need to be there, and I have also the facilities that are allowing me to to proceed. And we conduct virtual hearings, and I know the Nairobi Center also does that, and other centers. So to just be short is that I would say that as we have these emerging sectors, how prepared are we as institutions, as lawyers, as other ADR practitioners, because not only lawyers are ADR practitioners, how ready are we to deal with those? So, and I think we are on the right track when it comes to institutions that are in East Africa. Thank you, Karen.
Thank you, Ms. Francois. I think you really built on essentially what the role, especially in the place of arbitration. And you've listed all the specific institutions that we have, just so that everyone also knows that these are centers that are available to you, even as you're talking about chartered dispute arbitrators. So allow me to take the conversation back to Mr. Chairman Emeritus, Mr. Nyachoti, as I wait for Ms. Juma to... So Mr. Nyachoti, there's something that someone has asked in the participant box, which I just want to tie it up to the question I had. So we are practitioners, we're legal practitioners within these industries. we are trying to basically catch up with the age of over-information. I call it over-information because there's too much happening. And you've now realized that ADR is no longer an option. It's more of a necessary tool that needs to be assisted. So I have a dispute and I am stuck at where to begin. So where do I begin from? And as a legal practitioner, I want to maximize as much as possible when it comes to the aspect of opportunities. So when I ask where do I come from, there's always the debate of institutional versus appointment. So start us off on that. And also, how do you equip yourself? You mentioned that you're a member of, for example, the representative to certain bodies internationally. I don't know whether you are following with me. Yes, you're a member of certain bodies internationally. So I just want to understand. I'm a legal practitioner seated somewhere. I'm trying to understand how can I become a Mr. Nyachoti at one given point, and how can I have those certain titles that you're having against your name. What does that entail? So start us off with where it begins, how you get there, and essentially, even before you become a tutor, how do you get to become a fellow and the like, just so that everyone can understand the journey it takes to get to where you are.
Okay. Thank you. Thank you very much, Madam Moderator. I actually only introduced myself and didn't go into the discussion, but thank you for the opportunity to come back to that in a moment. So you're a lawyer attending this particular discussion. How do you move from this point to the point of becoming a fellow of the institute, becoming a chartered arbitrator, and the like? I think that's a very good question that a lot of the participants on this forum are interested in. In fact, one of the very first questions that was asked was, what are the qualifications required for you to qualify and enroll for a course on arbitration? Now, by virtue of being on this forum, it means you're an advocate of the High Court in any of the East African bars. You already have a primary profession, meaning you qualify to enroll for arbitration. So that's the very first point. Number two, and this is very, very good for each one of us, you've taken another step of showing interest in the space of ADR by joining this particular call, because it's talking about how to expand areas of practice within ADR. So what you need to do within these centers, starting with the Chartered Institute of Arbitrators, which is hosting us today, there are various programs for training on different ADR streams. There is arbitration, there is mediation, there's adjudication, and a certain level of conciliation. Now, within those streams, depending on your area of interest, I would then urge you to reach out to the centers. It could be the Kigali Center, it could be the Chartered Institute, it could be the Ugandan Center, and register for the training. For now, Kenya, the Kenyan Institute for the Chartered Arbitrators partners with both Tanzania and Uganda in terms of training, and Zambia. And we will be more than happy to assist, put together a training, even as basic as introduction to arbitration in the different areas where you are. If you're local already, you have a place, we are urging you, as the chair said at the beginning, to reach out to the institute. There's actually a course running in the coming week and in the week after that for arbitration. And I'm sure if you go to the website of the institute, you'll be able to see the other courses that are there. For experienced practitioners, there's a way of skipping the first 1 or 2 levels and going directly to accelerated route to member, or in the alternative, accelerated route to fellow. And therefore, depending on your areas of experience, on your years of experience, and typically it requires a minimum of 10 years as an advocate in your jurisdiction, then you are eligible to register to skip the earlier sessions of introduction and module 1 and go to an accelerated route, either to member level or to fellow level. Now, while you are climbing the ladder, as far as the qualifications are concerned, I always urge that you pair that up with some level of experience and mentorship. Where is this available? It depends on the practice in the different centers, but I'll mention the Chartered Institute of Arbitrators and the Kigali International Center as examples. within the Chartered Institute of Arbitrators, once you've qualified as a member, you then have an opportunity to be paired with a senior arbitrator for purposes of mentorship and getting some experience in the area of practice. By doing so, you get to sit in the arbitration, you get to learn the ropes, even before you get your very first arbitration. And people always ask, how do I get my very first arbitration? You can get it either by being appointed directly by parties, or the moment you sit in 3 mentorships, they are sufficient for you to do a report to the Institute. And that's the same thing that happens in Kigali as well, to do a report to the Institute showing you're competent to handle these matters. And by virtue of that, you can be appointed to run with an arbitration. Even as you wait for the Institute to appoint you, it would be particularly useful to find parties and don't look for big dispute, don't look for high-level dispute. Just start with what comes your way as one of the areas to learn from. Let me come to one of the questions that has been asked, particularly about training. Apart from learning the ropes as an ADR practitioner and arbitrator, how else can you participate in the growth, in the training, in the learning of arbitration? For me, one of the key areas has been training. Now, how do you get to train for the Institute? How do you get to train for any of the centers that have been mentioned? You first qualify, you get some level of experience, or you sit in with those who are training. For example, there's an introduction to arbitration course next week. You show your interest through the Institute. You then are allowed to sit in as a tutor. Sit in means hang in there, see how it is being delivered, and at some point you'll be allowed to pick up a session, run with it, and ultimately, sooner than later, you will be running with the whole thing by yourself. There's a question that has been asked by my senior colleague, David Nyakundi, on the chat. Why are there so few arbitrations within the area of pension? And it's directed at me. Let me try and respond to that. If a number of you, I would also interest you to, apart from arbitration, to explore the space of pension. If you look at pension schemes within the East Africa region, a lot of them are registered by trust deed and rules. In those trust deed and rules, there's always a dispute resolution clause. And if you look at it keenly, most trust deed and rules, if not all, provide for, at the beginning, an amicable approach to settlement of the dispute. And in default of settlement, it provides for arbitration. The question then is, how do you reconcile that with the other structures that have been set up for purposes of resolving disputes through the arbitration, through the pension tribunals? In my view, the parties have, through party autonomy, have the primacy to choose to resolve their dispute by way of arbitration. It's only when they don't agree, or they don't agree on the modality of how to resolve the dispute, that they then proceed to the tribunal. And nothing stops the tribunal from saying, I see a dispute resolution clause in your trust deed and rules. Can you explore that prior to coming to us? In other words, I am extending a possibility to the Institute for us to reach out to the various tribunals that are there and seek to just capacity build those tribunals so that matters which touch on arbitration coming before them, then they would know the appropriate reaction to those matters. I want to commend the Kigali Center. I want to commend the Ugandan ICAMEG Center. I want to commend the Chartered Institute of Arbitrators, because one of the areas that they have delved into significantly is on training of the judiciary. I can confirm to you that all members of the Supreme Court of Kenya have been trained through the Chartered Institute of Arbitrators. In fact, all members of the East Africa Court have been trained through the Chartered Institute of Arbitrators. All members of the COMESA Court have been trained through the Chartered Institute of Arbitrators. And several judges within the Court of Appeal, within the High Court. Now, we still require to work out an arrangement with the judiciary that allows us to go through all the ranks of judicial officers so that they're adequately equipped with the knowledge on how to deal with these matters as and when they come up. I want to make my last submission this way, Madam Moderator, if you allow me. I think it is not just to place emphasis that all of us need to be ADR practitioners. It's possible and it's a good thing if we can all be ADR practitioners in the different lines, but there are other opportunities, not only for tutorship within the various centers and institutes, but also in academia. A number of my colleagues are thriving in the area of academia and publication, and I think that's a very, very good space to grow within. Number two, a lot of the members on this call are legal practitioners, and therefore they probably are or should represent parties before various arbitral or mediation panels and adjudications. Finally, there's a growing area of administrative secretaries and administrators who help run mediations and arbitrations and give supporting services to those arbitrations. I think it is a good space for us to also double in even as we go on. Finally, is the harder to reach area of international practice. You can't talk about practicing internationally if you're not well equipped at the local scene. And if you're not good already and have appreciated and have a very good grasp of domestic arbitration, you probably then are not in a position or you're not ready to delve into the international scene. In other words, equip yourself with the local arbitral legislation and practice within your areas of practice. And through that process and through your networks, through the various interactions, you then have an opportunity to get an appointment here and there, to sit in with someone here and there, that eventually elevates you to the international arbitral space. And for you to be able to effectively apply that trade at that level, you must also equip yourself with very good knowledge on commercial arbitration, on infrastructure dispute resolution, on maritime and then investor state arbitration and commercial matters, among others. Thank you, moderator, back to you.
Thank you, Chairman Emeritus. And for sure, when you say that arbitration and ADR did change you, just listening to you every single time, there's something new to add. And the call to action for me, even as I'm going to the other panelists, and I'm reminded that there is a special rate for just park this because it shall be announced again, because he's talked about training. There's that course that he's spoken about, which is introductory course to domestic arbitration. There's a special rate that is being offered for East African Law Society members, which is $405 that was mentioned by Madam Chair. The dates are 2nd to 3rd of April. We'll communicate the same at the end of the session. So I'll move to Mr. Melly. Mr. Melly, if you are there, please turn on your camera. So Mr. Nyachoti has done a really good job in terms of taking us from the basics, which is you're a lawyer. You now want to be equipped as an ADR practitioner. You've done the necessary training. You're now ready to basically step into the market. And one of the things you spoke about so passionately was the rapidly evolving sectors that we've already spoken about. So my question would be, what did it take for you to occupy those tables or those rooms in respect of this particular disputes that occurred? Because one of the things we know is that your department has dealt with some of the most, for lack of a better word, intense disputes. We just want to understand, how do you get yourself to that particular position? And for you who's done your master's in dispute resolution, what was your call towards that particular direction? Because I know you went to University of Cape Town or somewhere thereabouts where you specialize in the same. So please brighten it. I am trying to do this so that by the time we end this call, from a practitioner's perspective, you have an idea of how to upgrade yourself. Yes, Mr. Melly, please proceed.
Thank you, moderator. Well, I think to a great extent, I would say that building capacity from my perspective, I think is a response to the, being responsive to client needs. And I think as practitioners, we at all times would model our services in such a way that we are able to provide value for the community, the business community, the clients that we represent. Choosing dispute resolution as an area for me was based on the realization that very many of the clients that as practitioners we serve on other kinds of matters are rapidly also moving their businesses into spaces where ADR in different forms is required. And some of the interesting arbitrations at regional level, at international level, and with the various international arbitration institutions, as Chairman Emeritus has said, starts from being on the space and building capacity. Most of these institutions, the opportunities to participate in those institutions start from taking an interest in one of the key sectors of arbitration. And you will see, and it's very much aligned with the theme of today's session, that some of these sectors, in looking for a solution to conflicts of laws, sectors that are typically cross-jurisdictional in nature, discovered that they constantly have to deal with conflict of laws when resolving disputes between one country, a company here and a party elsewhere, a state and an investor. The avenues of arbitration became some of the solutions to problems such as conflict of laws. Secondly, especially for the case of commercial arbitration, you will find that the business community is increasingly doing contracts. And when private parties or corporate parties do their contracts, they often want to incorporate in those contracts clauses that they think will provide them with a meaningful resolution of their disputes, either in terms of getting the best kind of expertise for that sector. It's a specialized sector: petroleum arbitration, petroleum disputes, energy disputes, and they, in most cases, would be looking to find a mechanism that enables them to seek out the expertise. Resolving issues such as efficiencies, and arbitration becomes the natural choice for very many of the business participants seeking to get into efficacious resolutions of the disputes. Within the region, you will see, for example, various international instruments have been entered into. Africa Continental Free Trade Area with a very defined dispute resolution mechanism. Many of the parties that are involved in project funding provide for arbitration. So for me, the rallying call was on the need to seek a diversity of information and knowledge through the Institute, through other institutions, and on the master's program you mentioned, but in a bid to provide to gather experience and information that is responsive to the evolving needs of the various clients. And it is one of a continuing nature. Some of these areas continue to evolve. Technology is evolving today. There are new areas. ESG is opening up new arbitrations. And that's why my rallying call would be that for the practitioners, that we would choose different sectors. It may be the sectors that we already specialize in. A practitioner, for instance, in property law and conveyancing and real estate would still be able to resolve disputes within that space. Practitioners in projects, mergers and acquisitions would still be able to get the training certification as well to be able to participate in resolving sector-specific disputes. Thank you.
Thank you, Mr. Meli, for that. And I think we're building onto the conversation, but just before we continue to the next panelist, allow me to invite Madam Chair, who needs to step out. So Madam Chair, you can just come on board and give your remarks so that at the very least, we don't have this session closing towards the end without your remarks.
Thank you very much, Karen, and all the other speakers. I've been listening with a lot of excitement about the exchanges that have been made, and I cannot overemphasize the importance of anybody, whether you are in the judiciary, like Honorable Justice Maydot, whether you're a legal practitioner, like a good colleague, Counsel Ken Melly, whether you're an arbitrator, like our emeritus chairman, and indeed, whether you are just joining into the profession, like our good friends, Francois, and also all the others who are present with us. So what I wanted to say is that this discussion really gives you a door, an entryway, an opportunity to step in to improve not only your day-to-day practice. I was listening to Ken Melly and all the different emerging areas. It is true, there are many, they are growing, and they are growing in complexity and in scope, and also on the jurisdictional footprint. And therefore, it becomes very important for each and every one of us to participate, take the first step first, understand what ADR is, what the different mechanisms are, and immediately incorporate them into your pre-dispute planning. So that if you're a practitioner, like I think everybody on this call is, then you're already starting to think about, so how are we going to go about a dispute when a dispute emerges? As chair, I've had the opportunity of looking at some agreements for arbitration and really just wondered, now how are we going to help these people? They want to get into arbitration, but the contract is all over the place. The agreement talks about the Kenya Arbitration Institute. That does not exist. We call these things pathological clauses, so that we can equip you to make sure that you do not make these mistakes. At the very least, please sign up for the upcoming introduction to arbitration. It's really an introduction to ADR, where we take you through the whole spectrum and we lay a foundation so that if you choose to follow ADR training as a mediator, as an arbitrator, as a construction adjudicator, you will find that there's a little bit, there's something for you. And the reason we do this is that the world is progressing into the space of multi-tiered dispute resolution approaches. So that we say, have an amicable settlement. If there's a dispute, please agree, negotiate. If that doesn't work, then go to mediation. We give a timeline in the agreement, and for the mediation, 30 days, 60 days, depending on what you want to provide. After that, you know that we are now really getting into the more adversarial scopes of dispute resolution, into arbitration or litigation, if you allow for that to happen. We strongly recommend against that, but some people feel that they want to integrate all the dispute resolution mechanisms. So it's important to understand how they work together, how they work against each other, and that will make you, as a practitioner, immediately, that is your first take home, immediately become a better equipped expert in legal practice. In addition to that, I think none of us have mentioned it, and it is important to do so. You will see somebody say that they are an ACI ARB. When we have that post-nominal, it means that you are an associate of the Chartered Institute of Arbitrators. And the qualification, like Emeritus Chair said, is not a qualification that is limited to Kenya alone. You get it from London. It is recognized in every single country in the world, because our membership spans for more than 160 jurisdictions, and all those are the 160 jurisdictions in the world that are commercially active. So everywhere you go, we call it the platinum qualification. So everywhere you go, you already be very, very quickly appreciated for being an associate. The next level is member. That is why we tell you, don't stop at associate level. Make sure you get to module 1. After module 1, you are entitled to calling yourself a member. As advocates of 10 years practice, I have to emphasize, then you are exempted for Module 2 training, which means that you sit an exemption exam, because sometimes we pretend that we know the law and sometimes that may not always be the case. Please observe, because we will tell you what you need to do, but it requires you to be very quick and to respond on the questions very quickly. Everything is, all our assessments are now done online. And then you go to, the platinum qualification, which is the fellow. You will see that our emeritus chair, he has put his, we call them post-nominals. There's CAB and FCIAB. FCIAB is the fellow. And that is the taught part of the course that we do. And when you become a fellow, then you are really at the highest rank. But there is a peer review mechanism, which also gives you a chartered arbitrator qualification. Especially the ladies, I want to throw this challenge to you. We are only 4 ladies in Kenya out of 40 chartered arbitrators. I mentioned that in Zambia, and they seemed more, they were more impressed by the fact that we have 40 chartered arbitrators in Kenya, because not every jurisdiction has that number. But I told them that the ladies were very few. So I just want to throw that challenge so that you begin with the expectation, the anticipation, and the preparation to take the journey. It is not an easy journey, but it is a very, very rewarding journey, because when you go to Francois in Kigali, you go to KIAG, she'll register you very, very quickly. She'll say, you're a fellow, you are very well equipped, and you almost get international, regional recognition immediately. For Honorable Justice Medot, I think Calvin, our emeritus chair, mentioned that our Supreme Court is practically 100% fellows of the Chartered Institute of Arbitrators. So that is a challenge that we will give to our colleagues in Ethiopia. We are very ready to support you the same way we supported you. And in fact, the judiciary here is very ready to come and give you a word of encouragement, also train you as well on the practical aspects. And like Calvin said, he's been training for a really, really long time. So you could not get a better person to guide you. I want to say one last thing, and this is because it pertains to enforcement of awards and settlements. And there's a huge, huge misunderstanding as to, first of all, the timelines within which you can set aside, the grounds on which you can set aside. You come and you sit for an introduction to arbitration, and this will clear many of the misconceptions that you may have. So any challenges that you may experience, any problems that you may experience, this will give you very many, it will expand your scope for the tools that you require to enforce. And we tend to train with a view to equipping you for not only Kenya. We train that we have a CIAB chapter, in Uganda, and we are looking forward, Honorable Justice Medot, to see whether we can start a chapter in Addis Ababa. And all of our colleagues, yes, and I saw the president of your is here. So if we have the judiciary and the president, I think we have everybody we need to start a chapter there. And we leverage technology. I think Ken really looked at this fairly well. And ODR, and also the new and emerging, very, very new emerging space of AI. And very many, very surprisingly, very many law firms are adopting AI in various scopes, and some of them to very large scopes. And it would be very, very helpful for you also to see how technology integrates with what we are doing here in arbitration, and also because whatever happens in Kenya, I will tell you that the case management that we have today, the electronic, the e-management, e-filing systems that we have originated from our members, our former president, who is a chartered arbitrator, Alan Gishui, was very forceful about doing the same things we do in arbitration happening also in in our courts. So there's a lot of scope for implementation. There's a lot of scope for improving yourselves individually. It is a whole new world for each and every one of you. I'm still learning. I'm really enjoying the journey, and it looks like it's going to continue being an exciting journey. And please take this as my invitation to join the Chartered Institute of Arbitrators, to join the arbitrating and ADR community around the world. There's something for everybody. The only thing we ask you to bring to the table is an open mind, a learning mind, and a student's attitude. The student who says, I think I can learn something new. I think I can make my life and the lives of those that I serve better. I think I can serve the cause of access to justice. And that person is you. I will unfortunately have to jump off because I have some commitments on this end. I've really enjoyed the engagement, and I'm looking forward to engaging with all of you through our new president, President Ram. I didn't get a chance to congratulate you. Allow me to congratulate you before all these the very eminent persons and group of people who are joining us in the webinar today. And he's a good friend. I know we'll continue to have a lot of engagements in this space as well. So with those many remarks, allow me to drop off and let you continue with the discussion. And thank you so much, Karen. You're doing a fantastic job. Keep up the good work. Yes, cheers.
Madam Chair, thank you so much. And thank you so much for your time and honoring us. And also the challenge. I think the call to action for everyone is wherever you are, move forward, onwards and forward. There's no retaliating backwards. Thank you very much. She set the stage for the next question in our next panelist. Please be patient with us. We're managing our time actually quite well. So Honorable Legislator.
I think I lost you there, Karen.
Yes. Apologies for that. Allow me to just restart. Madam Chair, the support of the courts, which essentially entails either enforcement of arbitral awards
Yes,
or
Karen.
adoption.
I couldn't get you. There's like a network glitch there. Could you repeat the question, please? Thank you.
Can you hear me now? Can you hear me now?
Yes, partly yes. Okay.
Perfect. We're good to go now?
Yes.
So with ADR processes, whether it's arbitration, mediation, we need the support of the courts. It does not operate in a vacuum, which essentially means that at the very least, there's some interaction, not some interaction, but there's interaction when it comes to ADR. For example, in arbitration, once you've completed an award, it still needs to be enforced. Or if a party within certain confines does not agree, and this again, certain confines, depending on the act, they can seek for setting aside of the said arbitral award. So my question to you now, as a member of the bench, would be, what are the challenges that you get to experience seated on the bench when it comes to whether it's enforcement, setting aside of this particular ADR mechanisms during the implementation, and what and how do you think we can remedy it, especially from a practitioner's angle, because you give us the perspective of the bench. But now, if you were to be on this other end, what would you do better? Yes.
Thank you very much for the question. If I'm allowed, I would like to support the comments made by Madam Chairman and Madam Emeritus as to the importance of training and being acquainted with the international scheme of arbitration in this regard, because it's very much connected to the question you just raised. And I would like to encourage everyone in my country, in Ethiopia, whether it would be in the judiciary or other practitioners, be the ad hoc practitioners as working as neutrals, or within the institutional arbitration scheme, to be involved in this program, because it will give us an excellent opportunity of knowledge transfer from our colleagues in East Africa and also the world. And such memberships and associations are like forever, and the knowledge sharing and the trainings are going to continue. So I think it's very important that we get acquainted with this. I mentioned these issues because, as you mentioned, from a practitioner's perspectives, and especially with regards to domestic arbitration, there is a huge gap of capacity in this regard. So many of the arbitral awards presented for enforcement in courts come from ad hoc arbitration tribunals. And even though they're doing a very excellent job in this area, there are gaps in which there may be knowledge gaps as to how to draft the awards in arbitration, presenting of evidence that comes, the presentation of evidence that should come with the award, and so on, which is vital for enforcement. So in this regard, there are award writing techniques, there are reasoning techniques, and also production of evidence techniques when you're presented with an enforcement of an award. So in this regard, I think the practitioners should be acquainting themselves fully with what is the international best practice in this area. And because of some confusions, there are some problems with regards to enforcement. And another issue that can be raised in this regard is the infant stage of the development of institutional arbitration in Ethiopia. And as you may know, institutional arbitrations have their own rules and regulations, from the commencement of arbitration to the finality till the production of the final award. And they put the credibility into the awards that are to be presented in the courts. And an example that I could mention in this regard was that an award was presented to the judges, which was a fabricated one. A fabricated award was presented to judges at one time. It is an experience in Ethiopia, and it was presented there for enforcement. And eventually, the case was followed up, and a solution was provided for. But it all made the judges very wary of the practitioners, how the practitioners are acting, and how the words presented are not credible in this area. Another issue I would like to raise in this regard is with regards to courts. So as courts, as judges, even though there has been continuous progress in supporting and in becoming co-arbitration in many situations, there still seems to be some discrepancies in understanding the competence requirements with regards to arbitration. As I've mentioned earlier, Ethiopia has promulgated the Arbitration Conciliation Procedure Act, which is very much in tune with the Unicentral model law on the matter. But as to practice, there seems to be entertaining some issues that are usually should be presented before the arbitral tribunal. So as mentioned earlier, as judges, we should all equip ourselves. What are the international best practices in these areas, and how we could possibly support arbitration and other ADR mechanisms in this area. As I mentioned this, I remember what prompted me to start to study ADR as a subject was like, I visited a state court in Texas one time. I went for a training, and we asked the judges how many case load files they have. And surprisingly, they said maybe 30 files per year, and most of them get settled. This is a state court, and most of them get settled, and not so many cases do actually appear before courts, because ADR is very much developed over there, and people resort to settling their disputes to take advantage of the efficiency that comes with it, the technical expertise that comes with it, and the technical expertise that comes with it, and the time constraints that comes with it. So we should, as judges, recognize that ADR helps everybody, including courts. The backlogging courts could be avoided with such cases like, for example, in the construction sector, we are expecting that the ADR system is developing, and many more are going towards it. But still, many contractual parties within the construction sphere, they adhere to the courts as the final determination of the disputes, rather than making arbitration as the final determination of disputes. So I really want to encourage that in this regard, and it's very important to understand the gaps within the judiciary vis-a-vis the gaps within the practice field, and come together and identify those gaps and find ways to properly address them in order to see a much more robust outcomes. Thank you.
Thank you, Lady Justice. And also just to say thank you for your time. One of the things I will definitely have noted in the chat box, you have a very loyal fan base of Ethiopian lawyers who are so honored to have you. Not that I'm just saying, I can see the applause that you're receiving, and genuinely thank you so much for making time. I know we don't have time for the last session, but I'll request Francois to just go next. Miss Juma unfortunately had an emergency and she had to drop off. But Francois, I think my question to you would be, what are the emerging trends? Seated at KIAC, are you noticing any emerging trends in the types of disputes being brought to the institution, especially in view of these key sectors that we're highlighting? I think if you answer that one question, we can have our closing remarks, and then we move to the plenary session. Meanwhile, I am requesting that our participants to feel free to ask questions in the Q&A in the chat section, just so that we can also try as much as possible to use the limited amount of time we have to deal with everything. Francois, please go right ahead. Thank you.
Thank you so much, Karen. We've been having some of the new sectors, as I mentioned, that are technology and construction. It's not new, but it's persistent, and it's been there for years. And I would say that it keeps changing depending on the growing of the center, or the growing of the economy. So we've been having different dispute in also energy. And I would admit that we've had some of the challenges having people who are trained and who have expertise in energy, and that is a call for action, I would say, for people who intend or who wants to be arbitrators, or who are already arbitrators, to engage in energy, because it's also a trend in Rwanda. Maybe I would skip to another thing that the center does for the young people to know. And we, since the KIAC started, we didn't have young professionals on the panel, and we've been now having them on the panel since for the last 4 years, 5. And one of the things that they use to access or to come across to KIAC is attending as tribunal secretaries in the proceedings. So attending as the tribunal secretaries in the proceedings help them to have that knowledge, and it can be requested through KIAC. You can have maybe a counsel who has a case here or anywhere else, and it's something that has been working and has been encouraging young lawyers, young professionals to engage in ADR. So other things are also capacity building, and we are keen to that because you cannot deal with arbitration without having expertise. By that, I say that, for to deal with these emerging sectors, there's a call for action for, have 1 or 2 sectors or you want to deal with in terms of expertise that will help you to be appointed when there's cases that, come across with that. Thank you.
Well, I think that brings us to the end of our interactive moderation. I will just move on to closing remarks. I insist, I think I've only seen one question, and we will answer that shortly to our panelists. But meanwhile, feel free to raise your hand, ask a question in the Q&A or the chat section. So back to Mr. Chairman Emeritus, as you give us your closing remarks, I just have one question for you that you can wrap this conversation with. You have been instrumental in shaping arbitration in Kenya and beyond through Chartered Institute of Arbitrators. What best practices should legal practitioners adopt to ensure effective arbitration proceedings? You've touched a bit on it, but I want you to further elucidate. But also, as you're doing the same, please give your closing remarks.
All right. Thank you very much, moderator, and to my colleagues for their contributions, which I am building up on. One of the, and someone alluded to it earlier on, one of the key things you must do as advocates is to appreciate that you are the ones who help the parties start the process of arbitration by including the arbitration clause in the contract. Now, where it is not well drafted, then the slippery slope starts at that point in time. Arbitration clauses are called the midnight clause because they are done late and in a hurried manner, and therefore they don't get sufficient attention. Please make sure your arbitration clause is well drafted. Now, what are some of the basic things that must appear in that arbitration clause? Number 1, that you're submitting the dispute to arbitration. Number 2, if you choose to have a multi-tiered approach, amicable settlement, adjudication, then arbitration, or amicable settlement, mediation, then arbitration, make sure the process flows from one to the other. And always anticipate that if it's amicable settlement, there might be a default in that process. So what should follow after that? That's number 1. Number 2 is the number of arbitrators. A lot of disputes are actually about how many arbitrators should there be, 1, 2, 3, or whatever number. Just state that the number of arbitrators. A lot of model law jurisdictions, they provide that in default of agreement of the number shall be 1. Now, the converse of that argument is this. I was recently asked by the Law Society of Kenya if I could become an arbitrator in a dispute. It's a dispute about construction of some premises, but the subject matter value is not very significant. And yet the advocates in this contract both provided that there shall be 3 arbitrators. Now look at it. You have tied your client, your respective clients, that they will resolve any dispute by way of arbitration. But it's a small project. Now, if they do not agree, and remember by that time when the dispute has arisen, chances are they are not agreeing on many things, then they will be forced to have 3 arbitrators. Now, the 3 arbitrators do not come cheap, especially because they have said they want three seasoned arbitrators. Now, 3 seasoned arbitrators don't come cheap. You're doing a disservice to your client by providing for 3 without taking into consideration the value of the subject matter. The third point that needs to be there is the seat of arbitration. Which law are we going to use to apply or move the procedural aspects of the dispute? Number 4 is, what is the governing law that will govern this contract? And where the arbitration or the contract is cross-boundary, then you have issues about currency, issues about the language to use, among other things. The last one, while I have full appreciation that a lot of arbitrations are now happening virtually, a large number of arbitrations are still also happening physically. So do provide for the venue for the arbitration. Now, one of our colleagues has touched upon it on the chat function by saying, why do we still have Singapore, New York, London as the venue or the arbitral destinations? I think we are slowly moving away from it. We probably need to do a better job moving away from it, because they are very good centers regionally within Eastern Africa, and therefore we should adopt those centers. But secondly, one of the things that people chase that we have probably yet to fully address, and my colleague Justice Tesfaye talked about it, is some of these arbitral destinations have very well developed legal systems, and in particular, the response of the judiciary to arbitral matters. So that is why people still chase London as the arbitral capital of the world, despite how costly it's going to be to travel as a team, to hire a Queen's Counsel or a King's Counsel, as the case may be. It's still very expensive, but they still choose it because it has a very sophisticated and developed system, particularly the judiciary, that facilitates rather than impairs arbitral proceedings. Now, I've been in this space for some time, and I have seen a lot of development in the Eastern African courts that, as today, becomes pro ADR as opposed to anti-ADR, as the case might have been in the past. So let's take advantage of that growth, that space, for us to be able to get there. Now, the second part of the question, apart from a well-drafted arbitral clause, there are very many other international best practices that we should borrow. I think we've already beaten one of them, which is to have capacity and to be able to deliver a succinct, cogent award. The other thing is to take best practices in terms of recusal for bias, or how to make disclosures in terms of independence and impartiality. It's an area that we still have to deal with. And then finally is a comment that tends to happen in this part of the world a lot, the suspicion towards the person of the arbitrator that they may have been compromised in one way or another. Now, if we are going to build this industry so that it is our bread and butter, and we are able to develop arbitral practice so that even foreigners who handle contracts locally are then comfortable for them to do the arbitration in the Nairobi Center or in the Kigali Center or anywhere else for that matter, we must be above reproach, and not just in reality, but also in terms of perception. And it's one of the best things that we must do, and guard the integrity of the arbitral process. Allow me to stop there and wish everyone on the call that they would do something about the plea that the various speakers have made today, to take the next step, and if you've already taken that step, grow to the next level, take on mentorship as we do it. I want to appreciate my fellow panelists and the moderator and in the same breath. Thank you very much, and back to you, Madam Moderator.
Thank you. Chairman Emeritus, and as always, thank you for your wealth of wisdom and sharing the same. We really appreciate you, and we also appreciate that you're always availing yourself just for us to harvest from your wisdom. Mr. Ken Melly, again, as you make your closing remarks, I have one last question. As East Africa positions itself, and this is based on what Besha has asked in the chat section, as East Africa positions itself as an arbitration hub, what reforms or innovations would you like to see to make arbitration more effective in resolving disputes, especially commercial disputes?
Thank you, Madam Moderator. I think I should start with the question that you have asked. And building up from what Chairman Emeritus has said and the question on the chat box, the reason why certain places are chosen for purposes of arbitration is because they are seen to be desirable seats of arbitration. A seat of arbitration has many implications, including, as to the applicable law. And for purposes of enhancing the attractiveness of East African region as a safe and desirable seat, a number of issues would have to be done to make it what is known as an arbitration-friendly or arbitration-safe destination. Among them is the certainty as to the legal framework on arbitration. For a long time, there has been a rallying call towards the modernization of the national laws to include the principles of arbitration, adoption of the model law, the UNCITRAL model law, and over time, improving the national laws, the legislation that supports the arbitration. The second one is arbitration is normally chosen because of qualities such as, finality of arbitral awards, consistency of the determinations that would come, the speed within which the disputes can be determined through arbitration. So the East African region becomes a better and a more attractive seat of arbitration when issues of efficiency, issues of quality are resolved. Judicial support is a very important aspect of arbitration, and I'm happy that Judge has very aptly described that. If you see the legal framework around arbitration across most parts of the world, is that there are certain junctions in arbitration that require judicial support. Appointment of arbitrators, setting up of arbitral tribunals or default appointments, determination of certain interlocutory issues, interim measures of protection, which are essential parts of arbitration. There is also support available through the courts, whether it's at the start of arbitration, during arbitration, post-arbitration in terms of enforcement proceedings for setting aside, and the like. So it requires an ecosystem that is trusted to have a robust framework that is facilitative of arbitration. Mauritius is a good example, I think, on the African continent of countries that have utilized
Am I the only person who's
reforms
lost your audio?
Can you hear me? Madam Moderator, can you hear me?
Yeah, you're good.
Sorry for that. I was giving the example of Mauritius, and through a set of deliberate reforms, has been able to attract a lot of international arbitration. And lastly, I would not overemphasize that the extent and availability of practitioners that would be able to provide support in arbitration processes is one of the other factors, especially from the perspective of international arbitration. International arbitration looks to see that in this region, in the event that we have to go to the national courts, do we have practitioners that would be able to support arbitration? As I close, and you've asked that I share some closing remarks, I think that the region is in a good space in terms of arbitration. There is a lot of progress that can continue to be made. Unfortunately, Africa as a whole is a perpetual exporter of disputes. We frequently find in international arbitration that there are disputes concerning African countries, sometimes involving resources that are seated in Africa or projects that are wholly in Africa. And yet these disputes are being resolved by practitioners outside Africa, in institutions outside Africa, and that is a gap that I think I would urge the participants on this platform to consider. The other issue is to resolve the twin problem of cost and time in arbitration, to find measures of, for the comfort of parties and users of the processes, bringing down the cost of arbitration by issues such as continuing to refine summary procedures through the various institutions and cost-cutting measures, and finding ways of managing delays that sometimes come up in arbitration. I would also ask that it is important to seek better consistency and predictability of matters such as the quality of awards, the enforcement proceedings, and the position that is taken by different national courts on issues such as finality of arbitration, setting aside, and the rest. And as I close, as lawyers and practitioners advising clients in different areas of law, it is important to have in mind sector-specific nuances as we advise our clients on formulation of arbitration clauses. If disputes are likely to be such that they require certain unique expertise in certain sectors, it is best to advise and assist clients from the beginning to have arbitral clauses that are both valid and not inoperable, but also those that will give them the best opportunity of a process, whether by way of utilizing expert evidence or appointments of arbitrators within the sectors. And I would take the closing opportunity to also thank the institution, the Institute, Chartered Institute, the EALS, my colleague panelists, and the entire of the audience, and to wish everyone a good weekend. Thank you.
Thank you, Senior. Thank you so much for your expert insights on this particular topic. We hope that we're going to have a follow-up session just so that we can build on the same. On to Honorable Lady Justice Maidot. I know we are pressed for time and probably only have 4 minutes. Yes, I only have 4 minutes. Allow me to just give Honorable Lady Maidot to give her closing remarks. I wanted to ask her something, but we're pressed for time. So allow me to just give her closing remarks. You can go right ahead.
Okay, thank you very much, Karen. I would first of all like to adopt my predecessor, a panelist, for his excellent closing remarks. And I would like to share all of them. And I would also like to add that in addition for being the seat of an international arbitration, there is a continuing debate now as to whether the international investment treaties are fair as regards to addressing the issues that come within the state, like the interests of the people. And in this regard, the regulatory freeze and other current trends are coming up. And as Africans, as we are attracting foreign direct investments, we should be not only in tune of holding on in bringing international cases as seats of arbitration, but also adding to the conversation of making the international investment treaties, whether bilateral and multilateral treaties, fair in terms of attending to the interests of the common people, like my colleague stated in the ESG dispute areas. So with that, I would like to conclude by saying that as regards to courts, we play a very vital role in ADR, as stated from the commencement of to the enforcement. So we should be able to understand the dynamics that come with it, and understand that being pro-arbitration or pro-ADR has various advantages as a country in attracting foreign direct investments, and also having the knowledge to manage our best interests through them. And the courts should play a central role in this regard by encouraging IDR practices and encouraging those with regards to the sectors, as mentioned above by my predecessor. We should be able to come together and have a viable an arbitration community in the end. And I would also like to mention the fact that East Africa, like the Chartered Institute of Arbitrators in Kenya, in the Kigali International Center for International, these centers have had a quite excellent experience in many regards, and they should be able to support other African countries like Ethiopia in knowledge sharing and capacity building. And I hope to see a much more coordinated efforts in making East Africa a viable space for foreign direct investment. Finally, I would like to thank everyone in the panel, Karen and everyone, and also special thanks to Evelyn Kamani for doing an excellent job in setting up such a wonderful webinar. Thank you very much.
Thank you, Lady Justice, and thank you for your time. Allow me to just let Francois, then we wrap it up. Francois, please. Francois.
Yes, can you hear me?
Yes. Just give your closing remarks. We wrap up the session.
Okay, thank you, Madam Moderator. To not, repeat what everyone has said, I just have like 3 call for action, or the way forward is to invest in capacity building as a person. Yes, there are some of the institutions like the CIAB, like the KIAC and everyone, but it's up to us as practitioners to invest in capacity building, and also be aware of new trends that are emerging in ADR, and also do some networkings anytime you can, so that you'll be on the table of ADR practitioners. Thank you.
Thank you very much. I first of all, let me say thank you. I'm alive towards the end, but first and foremost, I'd like to thank my esteemed panelists for making time to prepare for this session, because we've had enough sessions prior to this, and thank you for making time today. I am thankful for the audience for your engagement. There are a lot of questions in between, especially as pertains to certificates and the like. I am not in a good position to answer that, so I will hand you over to someone who's in a better position. But a special appreciation equally to the East Africa Law Society and CIAB, Chartered Institute of Arbitrators, for making this discussion possible and for their commitment to basically strengthening resolution mechanisms within the region. I think with that, as I leave it today, I'd like to encourage you, as I encourage myself, to proactively just reflect on our conversations. There's a lot we have to do in order to get where we are. As Mr. Melly has said, it's good for us to be very industry specific when you're considering these ADR mechanisms. But the whole point is the next time we're having this conversation, at the very least, invest yourself in capacity build and move to the next step. With that, we conclude today's panel discussion, and I'd like to wish you an amazing rest of the weekend. Allow me to just hand over to Evelyn. There is a training coming up. It's 2nd to the 3rd of April at a special rate of $405. Evelyn just needs to confirm. I think it's supposed to be online, and it's to be offered to, of course, the ELS members. So Evelyn, if you're on call, please feel free to go right ahead and give us the specific details. Yes, the poster is up there. Please take a screenshot of the said poster, register for the same. I am a testament to what arbitration can do. As you can see, there is the MCAB host nominal titles. Please kindly invest in yourself. You will see a few wonders here and there. Yes, so Evelyn, do you have anything you would like to add?
Great. Thank you, Karen, for that excellent moderation of the session. I would like to just highlight that this event today is as a result of an existing MOU that the Chartered Institute of Arbitrators and the East African Law Society shares. And part of that responsibility or the requirements within the MOU is to build capacity of the legal profession within the East Africa. So once in a while, we have these specific trainings geared specifically for the East African Law Society members. And this year we have 2 of them. And this is the first one in the year. We have slotted it on the 2nd and 3rd of April of this month. And there will be another one later on in the year. We will confirm the dates later. So the introduction to domestic arbitration or introduction to arbitration and ADR is the first step, as Calvin indicated in his presentation, that you need to take to become an arbitrator. It is the first module, or rather the first course you undertake on your path to arbitration. Thereafter, there are 3 modules, each with its own specific content. We have module 1 that deals with the law of arbitration the law of arbitration practices and procedures. We have module 2, which is on law of, module 1 is law of arbitration processes and procedures. Module 2 is laws of obligations, that is law of contract and torts. Then module 3, we have award writing and law of evidence. As you progress with your training, so does your post-nominal. So upon conclusion of the introductory course, and you're successful in the exam, you can apply to the membership of the institutes and acquire associate level membership and get the post-nominals ACIR. After conclusion of module 1, you can then upgrade from associate to member. And like Karen's name, you can get, she has the post-nominals MCIR. Then there's module 3. Upon conclusion of module 3, you have to sit a peers interview where you are interviewed by senior members of the institution, and they will accredit and see whether you're worthy to join the role of fellows. So it's at that point then you acquire the post-nominals FCIR. You've seen both Calvin here, Chair Emeritus, as well as our Chair. They have CAB in addition to their FCIR. So that means Chartered Arbitrator. And that is the level you get with years and years of experience. So that is our arbitration pathway. And we have other pathways. We have mediation and we have construction adjudication. The mediation, you just need to do the 40-hour mediation and you are good to go. So what I'd like to highlight about this introduction to arbitration is that it is what will open up the path to your arbitration journey. And mostly it's specific to those who've not had any experiences with arbitration before. For those who have had some bit of experience before, maybe they've had about 5 years of experience, either as party representative, they know a lot about arbitration. We have accelerated route modules. The accelerated route modules assume that you have all the experience and the knowledge required, because ARM, as we commonly refer to it, is an assessment on the module. What that means is there's the assumption that you know about arbitration, let's say arbitration law, arbitration practices, arbitration procedures. So you are coming on board to be tested on that knowledge. So for those who've had experience and just want to get the post-nominals of MCIR, but at least, that you can do the ARM. However, given that we are looking at value and some of the problems that we have currently, whether within Kenya or even the greater East Africa region on capacity, it also helps to take the long journey. But for those who've had experience, we have platforms for that, such that you don't have to start at the beginning, and then you just take the accelerated route, the accelerated route to member pathway. Then the other thing I'd like to highlight is that the Chartered Institute of Arbitrators has partnered with the Nairobi Center for International Arbitration, and you're hosting the second Nairobi Arbitration Week, which we are in conversation with EALS to be one of our partners in it. And the Nairobi Arbitration Week is aimed at bringing together all stakeholders from across the globe, converge in Nairobi and discuss about topical issues in arbitration. This year's theme is on arbitrating in the age of sustainability. And you have to be cognizant that if you're to progress our profession ahead, we need to be aware of what is happening around us and institute measures that are sustainable within our practices. So a lot of conversation is happening around energy, around tech. We have conversations of what the judge was talking about, the courts as well as the internet of the courts and arbitration. And also within that week, the Chartered Institute of Arbitrators will be hosting its 9th International Arbitration Conference. So we have a lot in store for you. So I will share with East African Law Society the details for anyone who'd be interested in attending. And from this partnership with East African Law Society, we'll be able to onboard you on SEAB discounted rates. So you'll be in safe hands. So this partnership aims at continuous synergy between our respective organization to ensure that our respective members get the best value from both institutions. So I will not take more of your time. We really appreciate that you joined us this afternoon. And I'm hoping that you've learned a lot. For those who would have further questions as to areas of arbitration or ADR in general, I will put on our contacts on the chat, and you can be able to reach out to us either on email or through phone numbers. But given that you are partners with the East African Law Society, if you reach out to them with any queries, I'm sure some of those will be directed to us and will be in a position to assist in any way. Also, I'd like to reinforce what our chair said, and something that Justice Maydot has also indicated. We have built the capacity of Uganda, and now they have a chapter. We have a chapter in Uganda, which we're hopefully looking to upgrade to a branch. So the same thing we can do across board, because we need that tool for capacity building of professionals across East Africa. So if you have people you would like trained in arbitration, in mediation, even in conciliation, the Chartered Institute of Arbitrators Kenya branch is very proactive, and we will get to where you are. So thank you so much. Thank you for your time. Thank you for your patience. And we look forward to hosting you either in the next coming up event or in any other event in the future. Asanteni.
All right, ladies and gentlemen, that brings us to the end of our webinar session. A special thank you to our partners from SEAB, our esteemed panelists, and to you, our dear attendees who took off your very busy Friday schedules to attend this very powerful session. We continue empowering and sharing information at the East Africa Law Society, and be on the lookout for our capacity building sessions in the month of March. Now, excitingly, we have 2 sessions lined up for next week. That's the first week of March. We have a session on unmasking deepfake revolution, and we'll be exploring the legal and ethical and societal impacts of a dystopian future. You'll be on the lookout for that. You know, deepfakes are on the rise, so you want to know what that means for the legal profession. And then secondly, we have a session on air and space blockade of civil aircraft, the law and its implications. If you are following events, you notice what's happening between in the East Africa region, where there are certain aircrafts that are not being allowed to cross in certain airspaces. So our aerospace committee will be dissecting that subject of airspace blockades. I guarantee it's going to be amazing. So thank you. We'll be sharing a recording of this session on your different email addresses, and we will also share with you our certificates of attendance in your different email addresses. So from the East Africa Law Society, we'd like to wish you a very lovely weekend until we meet again next week. Goodbye.